This is with the letter. So why are you giving me the letter? No, just 2, 3, 3, 4, 5. My lords, these are the judgments we are distinguishing. The ones I am now handing over
Yes.
are the judgments. Please give one, to Mr. Sibal. And lastly, what I am giving to your lordships is the timeline that I relied on, my lords, so that your lordships have in place.
That one place. You've circulated to Mr. Sibal.
Yes, my lords, absolutely. Each of them, as I hand over to your lordships, I am giving to. And my lords, this timeline I have consciously not included the EC events, because as your lordship said, that's not something that your lordships are getting into. I pretty much stuck to about the first week of July and stopped to the first week of July as far as these lists of events are concerned. So my lords, these three law are my submission yesterday for your lordship's kind consideration was that this is an artificial distinction sought to be drawn between a legislature party and political party. It has never been our case at all. In fact, we've right through said that it has the political authority of the political party. They are organically and integrally connected, and they're co-joined, and they have to be seen together. That's how the framers of the Constitution always looked at it. And in fact, whenever an attempt is made to segregate, they say, no, we must look at both. Now, that is further fortified if your lordships were to have para 4 of Schedule 10, which is a defense. Of course, I'm not on the defense argument at all, because according to me, I have not incurred 21A or 21B. So I'm not on the defense at all. But please have that why they should be considered together, and one has a bearing on the other. Please have para 4
That's important point.
of the 10th schedule.
Para 4 of the 10 schedule.
Yes, my lord. May I, with your lordship's permission?
Yes.
A member of a house shall not be disqualified under subparagraph 1 of paragraph 2, where his original political party merges with another political party, and he claims that he and any other members of his original political party, and please have two, for the purposes of subparagraph 1 of this paragraph, the merger of the original political party of a member of the House shall be deemed to have taken place if and only if not less than 2/3 of the members of the legislative party concerned have agreed to such merger. So even when you come to a defense, the bearing of what happens in a legislature party, in fact, they say it's deeming. It's a deeming fiction there as far as the defense of merger is concerned. I'm not for a minute suggesting I'm coming under para 4. I'm just drawing analogy from para 4.
Yes.
To say what bearing does the two have on each other. So when you come and say that this is only in the legislature party, nothing has happened in the political party. Well, even in Rana, which is one of the judgments I'll read out, when the defense was taken up of whether there is a split or not, the question was, should the split only in legislature party be seen or the split in political party be seen? Even there, the Supreme Court said, the speaker will not embark on an independent inquiry into whether there's a split in the political party. We'll just take a prima facie view. So they go hand in hand. And this whole argument that you're only the legislature party, not the political party, is a completely wrong argument in law and in facts. Now, my lord, straight away to the judgments. Kindly first have, my lords, Balachand versus B.S. Yadurappa. Just give. Judgment compilation 3D, volume 3D, PDF page 25, starting at 58.
Don't want to rely upon notes straight away.
But not straight, because this is for all the judgments. I will now just 4 judgments I want to cite and would request your lordships to read with me, because that is important for me.
What is that judgment compilation?
Volume 3D,
Volume 3D.
judgment compilation PDF page 58, which is the relevant para 113.
PDF page 58.
What para did you say,
Judges
Mr. Court?
compilation volume
113.
volume 1.
On page, PDF page. May I, with your Lordship's permission?
Yes.
The main questions which emerge from submissions made on behalf of the respective parties and the facts of the case may be summarized as follows. A. Did the appellants voluntarily give up their membership of the Bharatiya Janata Party? B. Since only 3 days' time was given to the appellants to reply to the show cause notices, as against the period of 7 days or more prescribed in Rule 7, subclause 3 of the disqualification rules, were the said notices vitiated? C. Did the Speaker act in hot haste in disposing of the disqualification application filed by Shri B.S. Yadurappa, introducing a whiff of bias as to the procedure adopted? D. What is the scope of judicial review of an order passed by the Speaker under para 21A of the 10th schedule to the Constitution, having regard to the provisions of Article 212 thereof? The facts of the case reveal that the appellant, along with Shri MP Renukacharya and Shri Narsimha Nayak, wrote identical letters to the governor on 6/10/2010, indicating that as MLAs of the Bharatiya Janata Party, they had become disillusioned with the functioning of the government headed by Shri B.S. Yadurappa. According to them, there was widespread corruption, nepotism, favoritism, abuse of power, and misuse of government machinery in the functioning of the government headed by Chief Minister Shri Yadurappa, and that a situation had arisen when the governance of the state could not be carried on in accordance with the provisions of the Constitution. Accordingly, they were withdrawing their support and from their support from the government, headed by Shri Yadurappa, with a request to the governor to intervene and to institute the constitutional process as the constitutional head of the state. The Speaker took the view that the said letter and the conduct of the appellants in moving from Karnataka to Goa and other places and issuing statements both to the print and electronic media regarding withdrawal of support to the BJP government led by Shri Yadurappa, and the further fact that the appellants are said to have negotiated with Shri H.D. Kumaraswamy, the leader of the state Janata Dal, and its members regarding the formation of an alternative government was sufficient to attract the provisions of para 21A of the 10th schedule to the Constitution. It was held by the Speaker that in the absence of any denial to the allegations made by Shri K.S. Eswarappa, the state president of the BJP, the same had to be accepted as having been proved against the appellants. In this regard, the Speaker referred to the views expressed by the Constitution bench in Kehoto Holohan, wherein one of the issues which had been raised and decided was the act of voluntarily giving up the membership of a political party may be either express or implied. Even greater emphasis was laid on the decision in Ravi S. Nayak, wherein it was observed that there was no provision in the 10th schedule which indicated that till a petition signed and verified in the manner laid down in the Civil Procedure Code for verification of pleadings was made to the chairman or speaker of the House, he did not get the jurisdiction to give the decision as to whether a member of the House had become subject to disqualification under para 21A of the 10th schedule or not. The aforesaid view taken by the Speaker has to be tested in relation to the action of the members concerned of the House, and it has to be seen whether on account of such action a presumption could have been drawn that they have voluntarily given up their membership of the BJP, thereby attracting the provisions of para 21A of the 10th schedule. In the instant case, the appellants had in writing informed the governor on 6/10/2010 that having become disillusioned with the functioning of the government headed by Shri B.S. Yadurappa, they had chosen to withdraw support to the government headed by Shri B.S. Yadurappa, and had requested the governor to intervene and institute the constitutional process as the constitutional head of the state. The said stand was re-emphasized in the replies to the show cause notices submitted by the appellants on 9/10/2010, wherein they had inter alia denied that their conduct had attracted the vice of defection within the scope of 21A of the 10th schedule. In their said replies, the appellants had categorically indicated that nowhere in the letter of 6/10/2010 had they indicated that they would not continue as members of the legislature party of the BJP. On the other hand, they had reiterated that they would continue to support the BJP and any government formed by the BJP headed by any leader other than Shri B.S. Yadurappa as the chief minister of the state. They had also reiterated that they would continue to support any government headed by a clean and efficient person who could provide good governance to the people of Karnataka according to the Constitution of India. And it was only to save the party and government and to ensure that the state was rid of a corrupt chief minister that the letter had been submitted to the governor on 6/10/2010. At this point, let us consider the contents of letter dated 6/10/2010, written by the appellants to the governor, which has been reproduced herein before. The letter clearly indicates that the author thereof, who had been elected as an MLA on a Bharatiya Janata Party ticket, having become disillusioned with the functioning of the government headed by Shri B.S. Yadurappa, on account of the widespread corruption, nepotism, favoritism, abuse of power, and misuse of government machinery, was convinced that a situation had arisen in which the governance of the state could not be carried on in accordance with the provisions of the Constitution, and Shri Yadurappa had forfeited the confidence of the people. The letter further indicates that it was in the interest of the state and the people of Karnataka that the author was expressing his lack of confidence in the government headed by Shri Yadurappa, and that he was accordingly withdrawing his support to the government headed by Shri Yadurappa with a request to the governor to intervene and institute the constitutional process as the constitutional head of the state. Although Mr. Sorabji was at pains to point out that the language used in the letter was similar to the language used in Article 356 of the Constitution, which according to him was an invitation to the governor to take action in accordance with the said article, the same is not as explicit as Mr. Sorabji would have us believe. The constitutional process as hinted at in the said letter did not necessarily mean the constitutional process of proclamation of president's rule, but could also mean the process of removal of the chief minister through constitutional means. On account thereof, the Bharatiya Janata Party was not necessarily deprived of a further opportunity of forming a government after a change in leadership of the legislature party. In fact, the same is evident from the reply given by appellant 9 reply given by the appellants on 9/10/2010 in reply to the show cause notices issued to them, in which they had re-emphasized their position that they not only continued to be members of the Bharatiya Janata Party, but would also support any government formed by the Bharatiya Janata Party, headed by any leader other than Shri B.S. Yadurappa as the Chief Minister of the state. The conclusion arrived at by the Speaker does not find support from the contents of the said letter of 6/10/2010, so as to empower the Speaker to take such a drastic step as to remove the appellant from the membership of the House. Now kindly have, my lords, para 142, page 64. My lords have para 142.
Yes.
On the very same day, that is 6/10/2010, Shri Yadurappa, as the leader of the Bharatiya Janata Party, Bharatiya Janata Legislature Party, in the Legislative Assembly filed an application before the Speaker under Rule 6 of the Disqualification Rules 1986, being Disqualification Application number 1 of 2010, for a declaration that all the 13 MLAs elected on BJP tickets, along with 2 other MLAs, had incurred disqualification in view of the 10th schedule of the Constitution. Immediately thereafter, on 7/10/2010, the Speaker issued show cause notices to the aforesaid MLAs, informing them of the disqualification application filed by Shri B.S. Yadurappa, and informing them that by submitting letters to the governor, withdrawing support to the government led by Shri Yadurappa, they had violated para 2(1)(a) of the 10th schedule to the Constitution, and were therefore disqualified from continuing as members of the House. The appellants were given time till 5 p.m. on 10/10/2010 to submit their objections, if any, to the said application. Even if, as held by this court in Dr. Mahachandra Prasad Singh, Rule 6 and 7 of disqualification rules are taken as directory and not mandatory, the appellants were still required to be given a proper opportunity of meeting the allegations mentioned in the show cause notices. The fact that the appellants had not been served with notices directly, but at the same were pasted on the outer doors of their quarters in the MLA complex, and that too without copies of various documents relied upon by Mr. Yadurappa, giving them 3 days' time to file the said notice to file reply to the said notices, justify the appellant's intention that they had not been given sufficient time to give an effective reply to the show cause notices. Please have then para 147 on page PDF 66. 147. May I, my lords?
Yes.
The procedure adopted by the Speaker seems to indicate that he was trying to meet the time schedule set by the governor for the trial of the strength in the Assembly. and to ensure that the appellants and the other independent MLAs stood disqualified prior to the date on which the floor test was to be held. Having concluded the hearing on 10/10/2010 by 5 p.m., the Speaker passed a detailed order in which various judgments, both of the Indian courts and foreign courts, and principles of law from various authorities were referred to on the same day, holding that appellants had voluntarily given up the membership of the Bharatiya Janata Party by their acts and conduct, which attracted the provisions of para 21A of the 10th schedule of the Constitution, whereunder they stood disqualified. The vote of confidence took place on 11/10/2010, in which the disqualified members could not participate, and in their absence, Shri B.S. Yadurappa was able to prove his majority in the House. Unless it was to ensure that the trust vote did not go against the Chief Minister, there was no conceivable reason for the Speaker to have taken up disqualification application in such a great hurry. Although in Dr. Mahachandra Prasad Singh, this court held that the disqualification rules were only directory and not mandatory, and that violation thereof amounted to only procedural irregularities and not violation of a constitutional mandate. It was also observed in Ravi S. Nayak that such an irregularity should not be such so as to prejudice any authority who is affected adversely by such breach. In the instant case, it was a matter of survival as far as the appellants were concerned. In such circumstances, they deserved a better opportunity of meeting the allegations made against them, particularly when, except for the newspaper cuttings said to have been filed by Shri Yadurappa, along with the disqualification application, there was no other evidence at all available against the appellants. As
67.
then please have
150.
para 151 at PDF, page 67. This is important.
You can come to 152.
Also on the same page.
Yes.
Well, it's para 152. We cannot lose sight of the fact that although the same allegations as were made against the appellant Shri Yadurappa were also made against Shri MP Renukacharya and Shri Narasimha Nayak, their retraction was accepted by the Speaker despite their views expressed by them, upon submitting the letter withdrawing support to the BJP government led by Shri Yadurappa, all the MLAs stood immediately disqualified under para 21A of the 10th schedule to the Constitution, and they were accordingly permitted to participate in the confidence vote for reasons which are not required to be spelled out. Then para 154. Having considered all the different aspects of the matter and having examined the various questions which have been raised, we are constrained to hold that the proceedings conducted by the Speaker on the disqualification application filed by Shri B.S. Yadurappa do not meet the twin tests of natural justice and fair play. The Speaker, in our view, proceeded in the matter as if he was required to meet the deadline set by the Governor, irrespective of whether in the process he was ignoring the constitutional norms set out in the 10th schedule to the Constitution and the disqualification rules 1986, and in contravention of the basic principles that go hand in hand with the concept of fair hearing. As we have earlier indicated, even if disqualification rules are only directory in nature, even then sufficient opportunity should have been given to the appellants to meet the allegation level against them. And kindly now have, my lords, the last para, 157, on same page. The appeals are therefore allowed. The order of the Speaker dated 10/10/2010 disqualifying the appellants on the membership of the House under para 21A of the 10th schedule of the Constitution is set aside along with the majority judgment delivered in writ petition so-and-so and the portions of the judgment delivered so-and-so concurring with the views expressed by Honorable the Chief Justice upholding the decision of the Speaker so-and-so filed by so-and-so. Consequently, the disqualification application filed by B.S. Yadurappa is dismissed. So, my lords, a much worse case, a case where the Chief Minister in question from the same party, they say they have no faith. But they said, where have they said that they are leaving the political party, they are forming a new political party, they continue to support the party. Thus, the extreme conclusion drawn to say that this ex facie attracts 21A is wrong. Because, my lords, if this is going to become the basis of 21A, that I express dissent within the party, then internal dissent, which is the bedrock of democracy and parliamentary democracy, will completely be thrown out of the window. Because at the end of the day, the moment anyone within a party expresses dissent, you say it's a 21A case. So in a much worse case, they said this is not a 21A case. And my lords, I'm not for a minute suggesting, as my lord the Chief Justice said yesterday, my argument is not that the majority within a party cannot attract the 10th schedule. The majority within a party can also disobey a whip or for whatever reasons, floor cross or align with the opposition party, go to the governor for falling of the government. That's not my case at all. My case is that to determine who is the rival faction under para 15 of the symbols order, there is an exclusive jurisdiction in the Election Commission of India, which looks at the parameters as set by your lordships on Sadiq Ali downwards to see which is the rival faction within the political party to be recognized. And my case right through has been that the legislature party and the political party go hand in hand. You are today seeking to draw an artificial distinction between a legislature party and a political party to say that you have shown nothing in the political party, you've only shown the legislature party. Whereas the legislature party definitely reflects the political authority of the political party as well. In any case, as far as a competent body is concerned, it has come to a conclusion that we represent within the Shiv Sena, the recognized Shiv Sena today. So my case is not that a majority cannot incur under 2(1)(a). My case is in the facts of the case. For you to say this was only legislature party and not political party is without any basis. In any case, the speaker has to decide it. You want to bypass the whole route and come to the Supreme Court in an Article 32 and say the Supreme Court must decide before the speaker, which is in the teeth of Kyoto. And my coming under a 32 was on Nabam, which is on an entirely different footing. That was the argument. Next, my lords, kindly have volume 3D, PDF 787 at page 815. Same volume, I read. That's right.
क्या page is
787.
Yes.
Tiger, 787.
I'm running against time. And 20, but I'd only trouble your lordships with one para since there's less time. Para 19.
Page?
815. Lordships may later see both the paras 19 and 20, but I'll only read 19. My lords have 19. The Constitution is not an ephemeral legal document embodying a set of legal rules for the passing hour. It sets out principles for an expanding future and is intended to endure for ages to come and consequently to be adapted to the various crises of human affairs. Therefore, a purposive rather than a strict literal approach to the interpretation should be adopted. A constitutional provision must be construed not in a narrow and constricted sense, but in a wide and liberal manner so as to anticipate and take account of changing conditions and purposes so that a constitutional provision does not get fossilized, but remains flexible enough to meet the newly emerging problems and challenges. The reason I'm citing this judgment, my lords, is in the context of Nabam, where it was said that the Constitution doesn't provide. As far as this, when does the notice period start? The Constitution does not provide for it at all. But some provision will have to be looked at. If a situation emerges when the Constitution was drafted and there was no 10th schedule to it at that stage, and a problem arises today, why can the court not interpret it in a liberal manner to take care of the fact that the constitutional values are protected? Right, Manoj? Now please have straight away of